Hello, everybody, and welcome to History/Law Bite number 333, dated December 23rd, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thank you so much for tuning in today. This History/Law Bite is entitled South Dakota versus Dole, 483 U.S. 203, 1987. Before I begin, however, I'd like to formally invite you to subscribe to my YouTube channel, Juarez Lee Shelton, M.A. And in addition to that, please also click on that little notification bell immediately to the right of the subscribe button. In doing so, you will receive notifications when I post new, exciting, and enlightening videos in history, law, political science, theology, and philosophy. Thank you so much in advance. You're the best. Again, this video is entitled South Dakota versus Dole, 1987. South Dakota versus Dole is an important case on congressional power and their constitutional ability to be able to set conditions on the states in areas traditionally reserved to the states in order to receive certain federal funding. So we begin in the same way the United States Supreme Court does. All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. So that takes us to the facts of South Dakota versus Dole. In the summer of 1984, the National Minimum Drinking Age Act, 23 U.S. Code 158, was passed by the U.S. Congress and signed into law by President Ronald Reagan on July 17, 1984. Part of the act directed the U.S. Secretary of Transportation to withhold a percentage of federal highway funding from states, 5% in the first year and 10% thereafter, in which the purchase or public possession of any alcoholic beverage by a person who is less than 21 years of age is lawful. Contrary to the title of the act, the purpose was to encourage uniformity by having all the states adopt a minimum age of 21 in order to purchase alcoholic beverages, not to consume them. Okay, the act did not in any way regulate how states chose to allow one way or another underage individuals to consume alcohol, which a great many of them do. All right, that's up to the states to decide. This act wanted all the states to make the minimum age to purchase alcohol 21. Okay? At this point, the petitioner, the state of South Dakota, allowed persons 19 years of age or older to purchase beer containing up to 3.2% alcohol. Okay? So, accordingly, the state of South Dakota initiated a lawsuit in the U.S. District Court where they sought a declaratory judgment that Section 158 violated the constitutional limits on the congressional exercise of the spending power and violated the 21st Amendment to the United States Constitution. For the purposes of this case, Section 2 of the 21st Amendment reads as follows: the transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. Thus, in repealing the 18th Amendment, which is in Section 1 of the 21st Amendment, Section 2 of the 21st Amendment returned to the states the power to control the sale, distribution, and overall regulation of alcohol and its consumption within their borders. The District Court would ultimately reject the claims of the state of South Dakota, and the United States Court of Appeals for the Eighth Circuit affirmed the District Court's holding. Appeal was then taken to the Supreme Court of the United States. At oral argument on April the 23rd, 1987, attorneys for the petitioners argued that the 21st Amendment to the Constitution granted the states plenary power over whether to permit the importation or sale of liquor and how to structure the liquor distribution system. Additionally, the state contended that the setting of minimum drinking ages is clearly within the core powers of the states reserved to the states under Section 2 of the 21st Amendment. On the other side of the podium, attorneys for the respondent, Secretary Dole, argued that the 21st Amendment was not contravened by the National Minimum Drinking Age Act. While the second section of that amendment does factually allow the states to regulate the sale and distribution of alcoholic beverages, it does not allow for the states to permit sales that the Congress seeks to prohibit. So that takes us to the issue involved in this case. It is as follows. Under the terms of the National Minimum Drinking Age Act of 1984, did Congress unconstitutionally exceed its spending powers and or violate the 21st Amendment by conditioning the receipt of federal highway funding on the states adopting a minimum purchase age of 21 for alcoholic beverages? I'll read the issue one more time. Under the terms of the National Minimum Drinking Age Act, did Congress unconstitutionally exceed its spending powers and or violate the 21st Amendment by conditioning the receipt of federal funding for the highways of the states in them adopting a minimum purchase age of 21 for alcoholic beverages? Okay? And the opinion of the court answered that question quite simply with a resounding no. On June the 23rd, 1987, in a 7-2 opinion authored by Chief Justice William H. Rehnquist, the Supreme Court affirmed the holding of the Eighth Circuit and the constitutionality of the National Minimum Drinking Age Act of 1984. Rehnquist's opinion held that, quote, even if Congress may be prevented from directly imposing a national minimum drinking age due to the 21st Amendment, indirect encouragement of state action to obtain uniformity in the states' drinking ages is a valid use of the spending power. It is constitutional for the federal government to attach conditions to funding grants to states as long as they are reasonable. The 5% loss of highway revenue was not unduly coercive. All right? Rehnquist's opinion was joined in full by Justices Byron White, Thurgood Marshall, Harry Blackmun, Lewis Powell, John Paul Stevens, and Antonin Scalia. Justice William J. Brennan Jr. filed a dissenting opinion, as did Justice Sandra Day O'Connor. So I'll give you a real quick summary of the opinion, all right, the cheat sheet, if you will. The bottom line holding of the court in this case was that it is constitutional for the federal government to attach conditions to funding grants to the states as long as those conditions are reasonable. And with respect to this case, the 5% loss of highway revenue from the federal government, all right, was not unduly coercive, all right? The states were more than free to elect out of this if they didn't want to, all right? And the loss of 5% was not seen as, literally forcing the states to comply. And so that's the summary of this decision. All right. So the Chief Justice's opinion contained the following points, which established a 5-point rule for this type of federal expenditure cut. Number 1, incident to the spending power, Congress may attach conditions on the receipt of federal funds. However, exercise of the power is subject to certain restrictions, including A, that it must be in pursuit of the general welfare. So that's the first condition, the general welfare. Section 158 is consistent with such restriction since the means chosen by Congress to address a dangerous situation, the interstate problem resulting from the incentive created by differing state drinking ages for young persons to combine drinking and driving, were reasonably calculated to advance the general welfare. Section 158 is also consistent with the spending power restrictions that B, if Congress desires to condition the state's receipt of federal funds, it must do so unambiguously. That's the second condition. In conditioning the state's receipt of federal funds, it must do so unambiguously, enabling the states to exercise their choice knowingly and cognizant of the consequences of their participation. And that C, conditions on federal grants must be related to a national concern. All right, so that's the third condition. The conditions must be related to a national concern. All right, if the federal government is going to condition the grants, they have to be related to a national concern, which in this case was safe interstate travel. Okay. Number 2, nor is Section 158 invalidated by the spending power limitation that the conditional grant of federal funds must not be independently barred by other constitutional provisions. The 21st Amendment here. Such limitation is not a prohibition on the indirect achievement of objectives, which Congress is not empowered to achieve directly, but instead means D, that the power may not be used to induce the states to engage in activities that would themselves be unconstitutional. So that's the fourth condition. The power cannot be used to induce the states to engage in activities that themselves would be unconstitutional. All right. Here, if South Dakota were to succumb to Congress's blandishments and raise its drinking age to 21, its action would not violate anyone's constitutional rights. Okay? Moreover, the relatively small financial inducement offered by Congress here, resulting from the state's loss of only 5% of federal funds otherwise obtainable under certain highway grant programs, is not so coercive as to pass the point which pressure turns into compulsion. So that's the fifth condition, all right? The loss of 5% of the federal funds here was not so coercive as to pass the point in which pressure turns into compulsion. So it's pressure, but it's not literally putting the state in a headlock, if you will, to comply with the program. All right. So I'll read those conditions one more time. Number 1, it must be in pursuit of the general welfare. Number 2, all right, it must be unambiguous in the intent of the Congress, so the states can exercise the choice knowingly and be fully aware of the consequences involved here. Number 3, the conditioning of the federal grants must be related to a national concern. Number 4, it can't encourage the states to do something unconstitutional. All right. And number 5, it can't be coercive to the level where it goes past pressure, but literally into compulsion. All right. Therefore, the National Minimum Drinking Age Act was a valid exercise of Congress's spending power in Article 1, Section 8, Clause 1 of the United States Constitution. All right. And the act did not run afoul of either the 10th or the 21st Amendments to the Constitution. The 10th Amendment, of course, being powers reserved to the states. So, Justices William J. Brennan Jr. and Sandra Day O'Connor each filed separate dissenting opinions in this case. Justice Brennan's dissent is as follows. I agree with Justice O'Connor that the regulation of the minimum age of purchasers of liquor falls squarely within the ambit of those powers reserved to the states by the 21st Amendment. Since states possess this constitutional power, Congress cannot condition a federal grant in a manner that abridges this right. The amendment itself strikes the proper balance between federal and state authority. I therefore dissent. Justice Sandra Day O'Connor wrote the principal dissent in this case, and it contains these important points. The court today upholds the national minimum drinking age amendment as a valid exercise of the spending power conferred by Article 1. But Section 158 is not a condition on spending reasonably related to the expenditure of federal funds and cannot be justified on that ground. Rather, it is an attempt to regulate the sale of liquor, an attempt that lies outside of Congress's power to regulate commerce because it falls within the ambit of Section 2 of the 21st Amendment. My disagreement with the court is relatively narrow on the spending power issue. It is a disagreement about the application of a principle rather than a disagreement on the principle itself. I agree with the court that Congress may attach conditions on the receipt of federal funds to further the federal interest in particular national programs and projects. Right? I also subscribe to the established proposition that the reach of the spending power is not limited by the direct grants of legislative power found in the Constitution. But the court's application of the requirement that the condition imposed be reasonably related to the purpose for which the funds are expended is cursory and unconvincing. We have repeatedly said that Congress may condition grants under the spending power only in ways reasonably related to the purpose of the federal program. The United States may impose reasonable conditions relevant to the federal interest in the project and to the overall objectives thereof. All right. We do not say that a tax is valid when imposed by an act of Congress if it is laid upon the condition that a state may escape its operation through the adoption of a statute unrelated in subject matter to activities fairly within the scope of national policy and power. In my view, establishment of a minimum drinking age of 21 is not sufficiently related to interstate highway construction to justify so conditioning funds appropriated for that purpose. Therefore, the judgment of the court in this case, U.S. Court of Appeals for the Eighth Circuit, affirmed. The laws applied here, Article 1, Section 8, Clause 1, as well as Amendments 10 and 21 of the U.S. Constitution, and the National Minimum Drinking Age Act of 1984, which takes us to the legacy of South Dakota versus Dole. South Dakota versus Dole was an important federalism case that affirmed congressional power to condition the receipt of federal funds on specific actions from the states as long as they are reasonable and related to the objective they're trying to attain from the states. In this case, it was indirectly mandating that all 50 states raise their minimum age to purchase alcohol to 21 or lose 5% of their federal highway funding in the first year and 10% thereafter. While setting a minimum age to purchase alcohol is obviously an area traditionally left to the states, it is arguable that the court sustained the NMDA Act for two reasons. Number one, states were free to not comply at all if they wished to not do so. All right? And number two, the loss of funding, 5% at the time, was so relatively minimal that it could not be ruled as coercive and therefore more constitutionally suspect. Additionally, the National Minimum Drinking Age Act did not in any way attempt to disallow states from allowing underage persons to drink, but only pressure them to adopt a uniform age of 21 to purchase alcohol. Had the act threatened to cut off all federal funding for noncompliance or attempt to force the states to disallow underage drinking in all circumstances, the court would have been far more likely to view the law unfavorably. Knowing what we do about Chief Justice Rehnquist, his position here is indeed a bit out of the ordinary, as in the next 2 decades he would be a very formidable opponent of a seemingly all-powerful federal government that attempted to bully around the states. He firmly believed that a federal government without limits served only to destroy federalism in this country, and when, in his opinion, the feds went too far, he would almost always side with the opposition. See U.S. versus Lopez and U.S. term limits versus Thornton, both in 1995, as well as U.S. versus Morrison in 2000 and Gonzalez versus Raich in 2005. And the most recent change to the National Minimum Drinking Age Act was a modification in 2012 from a 10% loss to federal highway funding to an 8% loss to states which did not comply. So the summary of this case, once more, is that it is constitutional. It is constitutional for the federal government to attach conditions to funding grants to the states as long as they are reasonable and related to the objective that Congress is attempting to attain. All right. And with respect to this case, the 5% loss of highway revenue was not unduly coercive. Okay. So that is the summary of the case in South Dakota versus Dole, properly referenced as 483 U.S. 203, 1987. So if you have any questions or controversies, leave them down below and I'll be happy to answer them. All right. If you learned something from this video, found it enjoyable, drop me a like. You have no idea how important that is in trying to establish your YouTube presence. And if you've not subscribed to my YouTube channel at this point, please do so now. Warresley Shelton, M.A. So I thank you all so much for listening. Hope you learned a thing or two from this video. And I conclude with the timeless words of one of my teaching role models, Mr. George Feeney. Believe in yourself. Dream. Try. Do good. And my own words. Take care. Stay safe out there. Be blessed. And I'll talk to you at the next video. Cheers.